in.
唔緊要，
完㗎啦呢個。
冇㗎啦，冇乜特別嘅。你係咪有長期
Do you have another meeting, a long-term care? No, no. I have a 9 o'clock appointment for public works. I don't want you to sit here by yourself.
你冇咩特別啊？新嗰啲條款
有一兩個問題，小問題。
哇，咁多人。早晨咁多位。
Good morning, everyone. After the last meeting, the Secretariat invited a dozen deputations to provide written submissions on the issue of criminalisation. 2 submissions were received from the Hong Kong Committee on Children's Rights and Against Child Abuse. I think members have read their submissions, and I see that they do not have any strong views on the issue of criminalisation. They urge the administration to continue to keep in view the situation. And the administration has provided a response, CB bracket 21860/1314 bracket 1. Maybe I'll invite Ms. Shear to brief us on the paper. The whole paper, Chairman? Yes, but you can be succinct. We've all read it. Thank you, Chairman. This paper is a response to issues raised by members at previous meetings, and also some proposed amendments to the bill. Based on the LRC's recommendations, we have included in this bill the provisions related to the Hague Convention on Civil Aspects of International Child Adoption, that is to prohibit parents from adopting the children, and members may wish to refer to para 2 of the paper. The bill proposes to empower the District Court to grant prohibition orders. As proceedings concerning custody or access rights are dealt with in the family court, members have suggested that the DC should be empowered to grant a prohibition order. And having considered members' views and having consulted the judiciary, we agree that the District Council should be empowered to grant a prohibition order. And the judiciary has also indicated that it is within the civil jurisdiction of the District Court, and according to the Hague Convention, only the CFI has the jurisdiction. And if the proceedings are dealt with in the District Court, there may be a confusion. So we're suggesting dividing the ordinance into 3 parts. That means some parts relating to the Hague Convention and some parts not related to the Hague Convention. And these are set out in para 6. For example, in part 1 is the preliminary, which sets out the interpretations for certain terms in the bill. Part 2 is provisions giving effect to the Hague Convention, which includes existing provisions of the CACO and also the proposed provisions relating to the handling of the Hague Convention cases, for example, location and recovery orders. And also, Part 2 would fall under the exclusive jurisdiction of the CFI. Part 3 related to the other provisions combating child abduction in Hong Kong is not related to the Hague Convention. For example, the prohibition order, etc. As for Part 3, both the CFI and the District Court will have jurisdiction over matters in this part. And The three parts in the CACO will be similar to the or the structure is analogous to that in the adoption ordinance. And we have consulted the judiciary. They agree that the proposal to divide the bill into three parts would give greater clarity. And we also invite members to note para 8. Members are concerned that the relevant parties in other court proceedings, for example, proceedings concerning custody or access of the child, may use the information provided to the court under a location order to the disadvantage of the child. Our members suggested that limitations should be imposed on the use of information provided for such purpose. And we therefore propose that the information provided in a location order may only be used for proceedings for the return of the child under the Hague Convention in Hong Kong, and that have commenced in Hong Kong. And we have applied the limitations to the three parts to give greater clarity. And basically we're preserving the original bill, and also we are proposing some amendments in the light of members' suggestions. We have reported to members on these amendments back in March. For example, the CFI will be empowered to amend or vary the recovery order and the location order, and also as for the prohibition order, this can be suspended. And as for the definition of the application for a prohibition order, we're going to propose an amendment. That is to say, the court will have set down a date for the hearing of that application. As for the Hague Convention notices, there will also be limitation on the notification or publication of such cases. That is, the parties involved should be made anonymous. And I will invite Alan from DOJ to see if there are any supplements. I'd just like to brief you on the structure of the revised bill. That is, as my colleague from the Policy Bureau has mentioned, there will be three parts. The first part is preliminary, which covers definitions and the long title. The second part is provisions giving effect to the Hague Convention. Now, members may wish to refer to the marked up copy, and part 2 starts at page 4. Part 2, provisions giving effect to the convention. That's the title at the start of the second part. As for clause 4A, 5A, after dividing the bill into three parts, we have to introduce the relevant and corresponding amendments. Page 5 of the marked up copy. 8A. Involves the Rules Committee constituted under the High Court Ordinance. That is, we divide the bill into three parts. Are we looking at Annex B? Right. The marked up copy. May I continue? Page 5. 8A. That is, we divide the bill into three parts, and then in the second part, the Rules Committee constituted under the High Court Ordinance that is mentioned here. And we need to provide a definition in the second part. As for clause A, clause 9, still on page 5, we're going to delete the existing section 15. It will now be moved to part 3 of the bill. Now, members can read page 18 of the marked up copy. Clause 21 or section 21 actually is the old section 15. Now, as mentioned by my colleague from the Policy Bureau, Section 15 deals with the prohibition order, prohibiting and removal of a child from Hong Kong, and we've now put this under Part 3. Going back to page 8 of the marked up copy, Section 16 will be renumbered 15 in relation to a location order. The new Section 15 that is on page 8 of the marked up copy, and then subsection 2A, as briefed at the Policy Bureau just now, as the court grants a location order, the court may also order that the information under this order may only be used for the applicable proceedings. And then on page 8 and 9 of the marked up copy, you see we have deleted section 17, and the whole paragraph is now moved to page 11 of the marked up copy. That is, we have moved the original section 17 to this part, and the number of sections have not changed. So after moving this paragraph, it will still be section 17. Next, on page 12 of the marked up copy, the original section 19 will be renumbered section 18. This is about notification of a stop order. As the prohibition order has been taken out and moved to part 3, under this new section 18, it should now only deal with the notification of recovery orders. And you can also see some parts being deleted in this section, and these have to do with the prohibition order. And as I said just now, as we have now divided up the bill, this part has been moved to the new part. And then on page 14 of the marked up copy, the original section 20 will be renumbered section 19, which originally is about the stop order, but as I said just now, the parts relating to the prohibition order has been moved to part 3, so this section only deals with recovery orders. And again, you see deletions. For example, in subsection 5 on page 15, and the following subsections have all been deleted. In fact, they have been moved to other parts of the bill, as these have to do with the prohibition order. Then they have been moved to part 3. Ms. Ho. Now I'm reading Annex B of the same paper, but the page numbering is... Oh, are you reading the English or Chinese version? Chinese. So I think there is a one-page discrepancy between the two versions. I don't know whether we're reading from the same version. I'm reading the Chinese version. I'm reading Annex B of the paper. Which page are you on? Sometimes a DOJ colleague was referring to page 15. Sometimes he was right, sometimes he wasn't. I just want to point this out. Page 15 is the deleted and renumbered section 19. that is authorized officer may detain child being removed, etc. Yes, but when it comes to page 14, I mean about the pages he cited, sometimes there is a difference of 1 page.
Perhaps I can refer specifically to the sections. I can follow you. I just want to point out that there is a 1-page discrepancy here. I'm worried that members might be confused. It's the same actually. Why don't you explain it more clearly? Next. I'm looking at page 18 of my paper, and here we've added the provisions under Part 3. The provisions under Part 3, the sections which have been added are actually the former Section 15 of the bill, which is moved under Part 3 and becomes the new Section 21. The content of which is about the prohibition order. The purpose is about the provisions regarding the prohibition, the order prohibiting removal of child out of Hong Kong without consent. And I'm looking at page 20 of the marked up copy. And this is the new Section 22, which is the notification of prohibition orders, and this actually is the original Section 19 of the bill, which has been moved under Part 3 here. On page 21 or in Section 23, and this is about the authorized officer who may detain child being removed out of Hong Kong in breach of a prohibition order. The drafting of this section is the same as Section 20 of the original bill. I've just put it under the provision which is applicable to local children being detained. Page 23. On page 23, you have the new Section 24, which explains clearly that the court may make rules of court giving effect to this part, and therefore the High Court ordinance and the District Court ordinance may make rules of court for the purpose of this part. So both the High Court and the District Court have the jurisdiction. Next, page 30, which is Part 5 of the bill, and Section 17, or rather Section 18 of the bill. Section 18, bracket 2. I think the policy already explained this earlier, and this is about the publication of a judgment in which the identity of a person referred to is to be kept anonymous. This was proposed by the Bills Committee, and we have made a corresponding amendment accordingly. So these basically are the proposed amendments. Do members have any questions? If not, then we'll move on to the next part. Legal advisor, I understand that you have some technical issues to raise. Why don't we discuss them as we go do the clause by clause. Could the Bureau take us through clause by clause through the new amended version of the bill?
咁所以你睇翻嗰啲改。
Please walk us through the parts which have been amended. Thank you, Chairman. I'd like to invite members to once again look at Annex B. Our colleagues from DFG have already walked you through the marked up copy, and I will basically draw your attention to the parts which have been amended. In Part 2, under Section 3 and Section 3. Section 3 is a technical amendment and also reordering the position of certain of the terms. And our DFJ colleague already explained to you that Section 3A, the title Part 1 is the title of Part 1 is preliminary. Section 4, it's about the district court having the power to impose a prohibition order. Therefore, we've added a definition for district court, and the parts regarding authorized officers have been moved to the part under to Section 2. Next, we move on to Part 2, 4A, which I think 5A and 5B is technical amendments to Section 3 of the original bill, which is consequential to the new three-part structure. In Section 8A, which is page 6 of the Annex B, our colleague already explained this part earlier. We are stipulating here that the Rules Committee of the Court may, pursuant to the High Court Ordinance, Section 55 of the High Court Ordinance, may make rules of court for giving effect to this part as appears to the committee. So it's about the rules which need to be made. Next, Sections 15 to 20. We have rearranged, renumber some of the original sections. It's about the recovery order. The CFI may prohibit a child from being taken out of a place, of a place which is not his usual place of residence. And before a ruling of the pursuant to the Hague Convention prohibition order. Next, I will walk through the amendments which has been made pursuant to proposals by members, and I think this has already been reported in the paper. And they include Section 15, bracket 2. Earlier, members proposed that the term "may reasonably obtain" should be further clarified. And having given this consideration, we have amended it accordingly under Section 2B, that is, may reasonably obtain in an official capacity of the child. Section 15(2)(a). Again, this is in response to members' concern, and we stipulate here that the procedures in relation to the information, the applicable information. Section 2, capital A, is about a location order made for any applicable proceedings, which may also provide that the applicable information provided in compliance with the order may only be used for the applicable proceedings. It is for the court to decide whether or not to impose such a restriction. So in other words, the decision or the discretion rests with the court. I'd just like to draw the committee's attention to this point. Chairman. So the court has the discretion as to whether or not to impose this restriction, right? and the applicant would have to make that application. The way it is drafted means that the court may impose that order, or the applicant may apply for the court to impose such a restriction. All right, please go on. Next, we have some textual amendments. The new section 16, 2B1. In response to members' suggestion, we have further clarified this part. So, taking the child to that country and so on, there's no change actually here. This is about the recovery order. And next, we come to section 18 and 19. Section 18 is about the recovery orders. We've not a notification order. We've not amended that section. We've just renumbered this section. The notification for prohibition order will now be moved to Part 3 under Section 22. In the new Section 19, authorized officer. Thank you, Chairman. Section 18, bracket 5. A stop order, a recovery order has been discharged on appeal by the court of first instance or suspended on appeal. So, in the absence of an appeal, I mean the order can also be suspended temporarily. So 2.5. So I think we need to add also recovery order has been discharged on appeal or by the court of first instance or suspended appeal. Or suspended on appeal doesn't cover all the possible scenarios. It should be suspended on appeal or by the court of first instance. So in the Chinese version, you add, bracket or the court of first instance, close bracket. Well, actually, we have actually considered this point as well as to why we should draft it in this manner. We have considered that in the provisions of the bill, the recovery order, earlier we have a discussion. That is, we've not added any provisions to allow the CFI to have the power to remove or amend or suspend the recovery order. And that's why we've also considered that there is no corresponding rules in the High Court to allow the CFI to unilaterally suspend that recovery order. So the way we draft this subsection is about suspension upon appeal. Who will be who will be suspending that? The Court of Appeal? Well, the applicant, when he applies for an appeal against the recovery order, then he will need to go to the CFI and inform the CFI that he is going to lodge an appeal. But still, it will be for the CFI to suspend the order temporarily. But we don't want people reading this section to have the impression that the CFI can. So which court will make that suspension order? It should be the CFI.
So on appeal, be it the court of first instance or the appellate court, it can suspend the order. The circumstances should be that it is on appeal. It is on appeal that the order can be suspended. So maybe you should use pending instead of on. The meaning of pending is that when the CFI has been notified that of an appeal application, it can order a suspension of the order. And when the case is taken to the Court of Appeal, it can also order a suspension of the recovery order. So it should be pending or on appeal. Maybe we can go back and consider the drafting of the English version, because in 5B
或者 by 即係意思好清楚啦，即係一係就上訴庭，一係就原訴庭係可以
that means very clearly it's either on appeal or by the court of first instance, but that's the case of discharging the order. But when it's suspended, it's on appeal by the court of first instance. So it means it's the CFI that orders the suspension. It doesn't say the Court of Appeal also has this power. So if you put pending or on appeal, then it will be clearer. Please continue. Next, the new Section 19. Under new Section 19, the authorized officer may detain a child being removed out of Hong Kong in breach of the recovery order. And we have not amended this arrangement, and as mentioned by a member, the detention arrangement in breach of relating to a child, relating to a prohibition order, this has been moved to Part 3, and for this section, we have moved the definitions for the authorized officer and immigration officer to Part 1. Then we come to Part 3. Clause 9A names the third part of the three-part bill, that is Part 3, other provisions combating child abduction in Hong Kong. About the empowering section, empowering the CFI to make a prohibition order, this will be made under the new Section 21, and the CFI and DC will be empowered to make a prohibition order. And then Section 21, subsections 4 and 5, the CFI and the DC may vary, suspend, or discharge a prohibition order under the section. And again, this has been reported in the March paper. I'm most concerned about this part. Setting aside the provision, in terms of implementation, how does the administration work with the customs and excise to prevent somebody from removing a child secretly out of Hong Kong? And is there such a list? For example, newborn babies, their facial features may not be very distinct. How can you ensure smooth implementation? I'm sorry, it's not Customs and Excise. It's the Immigration Department. Now, having made a prohibition order according to this bill, the applicant will be required to inform the Immigration Department, and this information will be placed under the Immigration Department system, such that when this person goes out of the territory, this can be identified and the Immigration Department, with the information, can rely on the powers given under this bill to detain the child. Now, my question is, what about newborn babies? What about the actual operation of the bill? What measures does the Immigration Department have? Perhaps I'll invite the colleague from the Immigration Department to tell us about their arrangement. Please turn on the mic. Please raise your hand. Which seat? Thank you, Chairman. I represent the Immigration Department. Now, in exercising immigration control, our immigration officers would check the person's appearance against the ID documentation to ensure that to verify the identity before we allow the person to leave Hong Kong. So we're very careful in this regard. And if there is a prohibition order imposed in our computer system, I mean, once we're notified, the person will be flagged in the system, and we can stop this person. What about photos of babies? And between 6 months to, say, a year and a half, when the baby starts to grow the teeth, the face may change a lot. How frequently will their photos be updated? We will ask the accompanying adult what the relationship with the child is, how familiar is the adult with the child, so as to find out whether the child is being legally removed from Hong Kong. Chairman, I don't know whether this is really effective. I hope the Immigration Department can be more careful about taking newborn babies in and out of Hong Kong. My question is not yet answered. As I understand, there won't be any photos, and even if there are, every 2 or 3 months or so, they may have changed a lot. So what about using somebody else's ID document? Now, let me supplement. For each child, the documentation does come with their photo, and if we find major changes, we will ask the adult to change the photos. But how frequent, depending on how large the change is. If the photo is completely different, we will remind the adult to change the photo of the babies to facilitate the customs clearance. I'm not very convinced by this answer. It's only when you approach the immigration control that the changes will be identified. Even if you remind the adult, I don't know how this will be done. After the court imposes an order, well, the Immigration Department has immediate record. Will the court inform you? The applicant or the parent will be responsible for informing the Immigration Department. That is, they will have to bring the paper to you, and the procedure is very simple. Yes, just bring along the relevant documents to our office, and we will input the information in the computer system so that when a child is being removed out of Hong Kong, he'll be detected. So, Chairman, has there been any instances of babies being stopped from leaving Hong Kong? Yes, if it's not in compliance with the legal documentation, the baby will be stopped. What about the number of cases over the past 3 years? I don't have the statistics at hand, but we have intercepted in some of the cases. And can you tell us on what grounds have you stopped the newborn babies from leaving Hong Kong? That is, what evidence do you have? Newborn babies, they all look alike, and they can't speak yet. So can you give us some figures? Are you talking about children under the age of 3? Yes, a number of cases of these children being intercepted over the past 3 years, and the reasons why they're intercepted. Mr. Albert Ho. Well, let's say you inform the Immigration Department that a child named so-and-so is now being prohibited from leaving Hong Kong. Does this information come with the person who has custody rights over this child? Let's say if the mother goes through customs, will the computer identify this parent and inform the officer that this person has custodial rights over a child who is the subject of a prohibition order? Now, if the Immigration Department is informed, we will also include this information in our database. Apart from the name of the child, does the information also include the name of the custodial parent or the custodian? The whole custody order will be scanned and uploaded to the system, and the frontline staff will be able to read everything. So, of course, there is the name, and of course there will be 2 names, the name of the child and also the name of the custodian. All information contained in the court order will be uploaded, scanned and uploaded to our system. Still on Section 21, Subsection 8. That is, in the light of members' suggestion to empower DC to make prohibition orders, we have included the new Part 3 of the CACO to specify under what circumstances a CFI and DC can make orders. I have a question. We talked about the family court of the district court in our discussion, but here it doesn't specify the family court, but only the district court. Does it mean that a practice direction will be issued by the judiciary that all relevant cases in the district court will be referred to the family court? Perhaps I can defer to my DOJ colleague to take this question. There are several elements apart from defining what the district court is. We also have empowering sections. And the district court can also make rules for this purpose, and we consulted the judiciary as we drafted this section. They are aware of our legislative intent, and they will also issue relevant guidelines. So they will use the family court, right? A legal advisor? Chairman, on this new definition, I'd like to ask the administration. Does it include all provisions relating to the custody of or welfare of a child in Hong Kong? Well, this is our intention, and maybe I will defer to our DOJ colleague again. In amending this provision, we've drawn reference from other provisions in the laws of Hong Kong, and we have also set out all the provisions relating to the welfare of the child. Next, the new sections 22 to 24. Section 22 is a renumbering that is in relation to the arrangement for the notification arrangement. This part has been moved from another section to here. And then next, 22(1)(b). In light of members' concern, and that it will be subject to abuse, we're now proposing that Section 22(1)(b) concerning a pending application for a prohibition order is one for which the application has already been filed and the date of hearing of the application has been fixed by the court. We have reported to members in our paper in March. In 22(5)(a) and (b), it provides that the prohibition order may be varied, discharged, or suspended on appeal by the court that made the order. Again, that was reported in the March paper.
Section 23 is about authorized officer detaining a child from being removed out of Hong Kong in breach of a prohibition order. Again, this is a renumbering exercise. We've not amended the arrangement. We've just relocated the original provision to and given a new number. Our DFJ colleague already elaborated on Section 24. This is because the CFI and the District Court may, pursuant to Part 3 of this bill, can impose a prohibition order. So, subsection 2 said that the power, the Rules Committee may make rules of court giving effect to this part as appears to the committee to be necessary expedient, and the court should be able to make rules for the purposes of this part. And finally, Part 5, Section 18, which is the dissemination of the judgment and the information of the parties concerned would need to be kept anonymous. Thank you, Chairman. If members have no further questions, does the legal advisor have anything further to add? Well, if not, I think we've finished the clause-by-clause scrutiny of the bill. I believe, well, the Secretary, could you tell us about the timetable? When will you be able to give us the information? I mean the information from the Immigration Department. And also the amendment I proposed just now, that was a simple one. Immigration Department, I believe, within a week or a few days' time. Okay, shall we just circulate that? So the information from the Immigration Department, that is how can you effectively stop a child from being taken out of Hong Kong illegally. That does not affect my vote on the passage of this bill, so we don't need to convene another meeting. But you may take this back to the relevant panel for follow-up. Okay. So we will wait for the information from the Immigration Department. Ms. Ho said clearly that such information will not affect her position in respect of this bill. So I don't think this Bills Committee will need to meet again. If you have any documents or if when we have any new provisions, we will circulate it among members. If there is a genuine need, that we can hold a meeting on that particular point. But I don't think really that will be necessary. Is there anything else? Okay. So if there's nothing else, then we may now adjourn. Thank you.